Good morning. Welcome to session 2 of the PENC Raleigh seminar. Again, I am Katie Cox. I will be serving as moderator. If you have any technical difficulties, please use the chat box and I will assist you. We will be taking questions at the end of the session. You can type those into the questions box and I will ask those out loud. We do have several polls and we encourage you to participate in the polls today. Our speaker this morning is Rebecca A. Bowman, Esquire, PE, DFE. She's the NSPE Senior Director of Ethics and Professional Practice. Rebecca Bowman is the principal of a woman-owned business in civil engineering, dispute resolution, real estate, and legal services. She is experienced in boundary law issues, engineering design and forensic analysis, construction project management, dispute resolution, real estate, and small business startups. She is a registered professional engineer and a certified arbitrator, mediator, and Christian conciliator. She is a frequent CPE lecturer for a variety of providers. She received her BS degree in civil engineering from the University of North Dakota, her MBA degree from Oklahoma University, and her JD degree from Duquesne University. She is a diplomat of the National Academy of Forensic Engineers and is currently pursuing MS in sustainability from Penn State. Ms. Bowman is involved with the National Society of Professional Engineers, the National Academy of Forensic Engineers, the American Arbitration Association, the Institute for Christian Conciliation, and the American Bar Association. Ms. Bowman, thank you so much for being with us today.
It's my pleasure. Thank you for coming, and I hope I'm really not as obnoxious as that bio sounds. We're going to talk today about an ethical challenge related to the collapse of the I-35W bridge in Minneapolis. That's who I am. I'm going to leave it up there so you have time to, snapshot it if you want that information. I am the ethics hotline for NSPE, so you are always welcome to call me with any ethical challenges, preferably before you do something, rather than after you've already done the something. So please feel free to give me a call, send me an email, whatever works for you. I am an ethical resource both inside and outside. In association vernacular, I am in front of the paywall. So I am accessible to both members and non-members. I do have a limitation on my availability with respect to non-members, but I do not have a limitation with respect to my availability to members. So please ask before putting yourself in an awkward situation. So hopefully I can help with that. Okay, this is a picture of the bridge that we're going to be talking about. This is the I-35W span across the river in Minneapolis, and it was a beautiful summer day when that photo was taken. Our objectives in our time together this morning are to discuss the history of the bridge, review the NBIS bridge inspection procedures and the responsibilities of inspectors, because some of those may be kind of surprising to you. We're going to summarize the recommendations from the NTSB investigation, review the ultimate assignment of damages, and then we're going to take a closer look at the NSPE Code of Ethics and some relevant analogous Board of Ethical Review cases, so that you come away this morning with, I hope, a clearer understanding of what your obligations are when you encounter a situation that involves risk. Okay, this is a little bit about the bridge itself. It was designed by Sverdrup and Parcel and Associates, crosses the Mississippi River in Minneapolis. The design was approved by the Minnesota Highway Department in 1965 and opened to traffic in 1967. It collapsed August 1st of 2007. It is a combination of deck trusses and steel beam approach spans. There are 14 spans total. It is perfectly symmetric. Spans 6 through 8, are the deck trusses, so exclusive of the approaches, and that is 1,064 feet. Of the types of trusses that we run into, we have through trusses, where the cars are going between the upper and lower span, and deck trusses for both the upper and lower span are below the vehicles, and in fact, the upper span is what's supporting vehicle traffic. The I-35W deck truss, meaning that the entirety of the truss is below the road surface, was used by 141,000 vehicles per day. And it is a fracture critical bridge. And we're going to talk a little bit more about exactly what that means. But just as a reminder, if you haven't done trusses in a while, the top member of the truss is called the upper cord. The lower member of the truss is called the lower cord. Terribly, terribly creative. And the deck here was 8 lanes wide, 113 feet. And you can see that a portion of the deck is cantilevered. So that's the overall structure of the bridge. The I-35W superstructure spans those 6 through 8 because the approaches, the north and south approaches, are not in structural play. So the part that works as a unit is 6 to 8. It has 2 trusses, 27 floor beams, which are welded, built-up members in the trusses, stringers that are 27 inches, 14 each between each floor beam at 8-foot 1-inch centers. And the bracing are L members. So just for orientation, we have the stringers at the top, the floor trusses, you can see a little bit down from the top. We have the west truss, the east truss, and then there are bracing members. And all of that is above the ground surface. Okay, so we have truss members and nodes that come into place here. Along the upper cord, the members are connected with gusset plates. They are connected with both vertical members and diagonal members. They all come together at the gusset plates. And excuse me for 1 second, I forgot to remove my phone. Sorry about that. Okay, our upper cords and the vertical members are welded box shapes. The diagonals are welded H shapes, which you can sort of see from the shadows here. And the nodes are riveted gusset plates. And the rivet configuration is something that gets a great deal of attention in terms of the design of the rivets and evaluating the ultimate strength of the members with every puncture hole. Okay, the truss is symmetric. So what we have is a center point, and the trusses are numbered from south to north, and then 13 prime begins the north half of the bridge. So we've got piers 5 and 6, piers 6 and 7, and 7 and 8 are the spans that we're working with. Failures occurred at 10 and 10 prime. And you would expect there to be a symmetric failure since it's a perfectly symmetric bridge. Were it not perfectly symmetric, you might get a different distribution of failures, but since it's perfectly symmetric, we would expect a symmetric failure, and in fact, we got one. Okay, here are the modifications that have occurred to the bridge since it was opened in '67. In 1977, 2.5 inches of concrete was added to the deck to provide additional cover to the reinforcement. In 1998, the median barrier and traffic railings were replaced, an anti-icing system was added, and rehab was performed on the piers, the slab, and the cross girders. In 2007, there were repairs to the deck slab and the expansion joints. The de-icing system was replaced, and that work was in progress at the time of the failure. Now, think about that for a moment. you have an extremely busy bridge. That it's partially closed. So what would normally, the traffic that would normally be splayed across a number of lanes is concentrated into one lane. And add to that, we've got the construction equipment that's on the bridge. So just, keep those little things in mind as we take a look at this. Okay. This is the first of the polling questions. Did the 1977 update to the bridge, adding 2.5 inches of concrete to the deck, A, have no effect on the bridge design, B, increase the live load, C, increase the dead load, or D, both B and C? And Katie has opened the poll.
Yes, we'll give you all 30 seconds. Okay, 10 more seconds for votes in. All right, the results, 73% said increase the dead load and 26% said both B and C.
Okay. In general, the accepted answer would be C. I have seen some elaborate arguments as to why it would affect the live load as well. But it's absolutely uniformly agreed that it does increase the dead load. Now, I don't know about you, but if I have a change order to a contract while I'm building it that increases the dead load, I go back and sort of take a look at my numbers. Yeah, no, that didn't happen here. Okay, the NBIS regulations apply to all publicly owned highway bridges longer than 20 feet that are located on public roads. So they require a bridge inspection at intervals not to exceed 24 months. So that means anytime, just to put those two things together, anytime you have a highway bridge longer than 20 feet on a public road, the inspection must be completed at least every 2 years. So somebody's looking at the bridge every 2 years. And we're going to take a pretty close look at the bridge inspection process because it's important to understand that process in order to understand the role of the PE in all this. So a bridge safety inspection includes 5 tasks. The first is planning, identifying in advance the needs for traffic control or traffic restriction, the need for access and safety equipment, inspection tools, personnel, daily schedules. Unlike a land-based construction project or inspection process, a bridge inspection process has additional safety factors because you are necessarily in an elevation situation. So the planning here is very much safety focused. Okay, the second step is preparation, which means exactly what you think it means. Gather the equipment that you need and identify the services that are required. So then we do the inspection, performing visual and physical evaluations of bridge components and all bridge elements according to the National Bridge Inspection Standards. Now, the general expectation is 100% touch or arm's length. So there's no, yeah, I can see 20 feet over there. The expectation is that you will be either able to touch the member you're examining or you will be within arm's length of it. The fourth step is reporting. So that involves documenting the methods and procedures used and the findings from the inspection. And finally, the recommendations. Preparing a list of prioritized maintenance, repair, and replacement activities. And we're going to talk a little bit later about whether or not an inspector has closed facility powers. Okay, a bridge inspection report is a legal document and must be sealed by a PE. It includes specific, detailed, quantitative, where that's possible, observations and photos. So there are qualification criteria from the National Highway Administration. A program manager must be a PE and have successfully completed the training course, or a combination of 10 years of bridge inspection experience and the training course. So a program manager might not be a PE. The team leader must be a PE and successfully complete the training course, or a combination of bridge inspection experience, NICET level 3 or 4 certification, a degree, and a training course. One of those two roles must be filled by a PE. So there are options, qualification options for both roles, but one of them must be a PE. The bridge inspector's role is to be continually on guard for minor problems that can become costly repairs, to recognize bridge components that need repair in order to maintain bridge safety and avoid the need for costly replacement, and to make recommendations to close a bridge if necessary. So yes, the bridge inspector does have closed facility power. The bridge inspector must also identify defects and changes in conditions that warrant a review of load carrying capacity of the bridge. Now, that's a biggie. In fact, that's a critical one. This came into play in the I-35 bridge. This came into play in the Memphis bridge. It frequently comes up. But one of the important characteristics is comparing the present conditions to the historical conditions as documented by a previous report. The only analogy I could come up with, and I'm sorry for the gentleman, but if you're a lady, the analogy here is going in for a mammogram. They don't just take pictures today. They take pictures today and compare them to a historical record, exactly looking for changes. All right, so we've talked about his responsibilities. What are the bridge inspector's liabilities? In the event of negligence in carrying out the basic responsibilities described above in the previous slide, an individual, including department heads, engineers, and inspectors, is subject to personal liability. That's huge. Strive to be as objective and complete as possible. Accidents that result in litigation are generally related, but not necessarily limited to, deficient safety features, failed members, failed substructure elements, failed joints or decks, potholes or other hazards to the traveling public, and improper or deficient load posting. Anything said or written in the bridge file could be used in litigation cases. And in litigation involving a bridge, the inspection notes and reports may be used as evidence. Now, if you've ever participated in, let's say, a mediation, one of the things that the mediator tells you straight out of the gate is that nothing said during the mediation can be used in court. You cannot subpoena the mediator's notes. You cannot subpoena anything presented to the mediator. You cannot subpoena any, provide any questions about settlement discussions. So a mediation is as far from a bridge inspector's report as you can get. In a bridge inspector's report, the whole file is available for discovery. Not one note, not one shard of paper, not one email, not one text is protected. There is no attorney-client privilege or anything like that. Anything in the bridge inspector's file is subject to subpoena. In general, I would think that doesn't actually matter. You know going in that you're preparing an official record. And as a general practice, you shouldn't write in your any file something that you would be embarrassed to have disclosed later, like don't use bad language, don't say snarky personal stuff, just nothing but the facts. So that exposure to subpoena is significant to understand, but it shouldn't make you handle a bridge inspection any differently. Now, the liability question is a whole other ballgame. And thinking back to that standard of touchable or no more than arm's length away, if a bridge inspector gets cavalier about that or inspects every other member or something like that, that liability can be devastating, absolutely devastating. And you'll notice it's personal liability. There are a couple of states that do not permit indemnification of a bridge inspector by the employer, which means that the employer's insurance would not be answering those claims. Be sensitive to that. By the way, you're not in one of those states, so that's good. But be aware that there are states that prohibit an employer from indemnifying a bridge inspector for negligent work. Okay, this is sort of a little bit for the fun of it because it's cool, but this is a picture of a snooper being used. So you can see that the crane is up on the deck and it has a C-shaped arm that comes down and carries the inspector about. Inspecting a large bridge like this takes several weeks to days, and the inspection includes the superstructure, the substructure, and the deck, which makes sense. Now, we've seen some enthusiasm lately for inspections conducted by drone. I don't know exactly where that's going. I rather expect that it will gain in popularity. For one thing, it's safer. And if you attach a robotic camera to the end of maybe a snooper arm like that, you can get all of the outside pieces that way if you want to, and send the drone in to do the interior pieces. Requires some very tight drone operation because, again, the images must be within touching distance or arm's length. That standard has not varied whether a drone is being used or not. Okay, here are the I-35 bridge condition ratings over the years. So one of the conversations we need to have is, what is structurally deficient? Structurally deficient means a bridge has deterioration to one or more of its major components, that being the deck, the superstructure, and the substructure. And that deterioration results in a component condition rating of 4 or less. So you see here in Table 5, the condition ratings, sufficiency ratings, and status for the I-35 bridge, I-35W bridge, between 1983 and 2007. Okay. In 83, 84, 85, 86, 87, 88, 89, 90, you see that everything is well above a 4. There's 6s, 7s, a couple of 8s. Okay. So in 91, however, we see that we have gone to structurally deficient. And it's structurally deficient the rest of the time, except for 1999. The reports indicate structural deficiency. All of the structural deficiencies have occurred in the superstructure, but it renders the entire structure structurally deficient. So that's the status that was being sent out. So again, remember, our truss numbering is symmetric. So span 6 covers the numbers 1 through 8. Span 7 is 8 through 8 prime, and span 8 is 8 prime through 1 prime. That makes perfect sense, again, because we have perfect symmetry. And remember, the failures that we had were at 10 and 10 prime. Okay, what we find at both 10 and 10 prime is bowed gusset plates. I believe that the 10W looking north picture shows it the best. You can actually see that the line on the side of the gusset formed by a vision of the side of the gusset is not a straight line. U10 eastbound on the east side of the bridge, looking north, you can see that, again, that line is not a straight line. And it isn't terribly obvious from that photograph how the gusset plate is bowed, because it could also look like it's a little bit crumpled, but it's not. It's bowed relative to the surface of the gusset plate. It's convex. U10 prime east, looking south, is bowed. Not so obvious in that picture at all. But U10 prime west, looking south, it's obvious that that is not a straight line. So we have documentation of bowed gusset plates at exactly the failed locations. The bridge collapsed August 1st, 2007. It was 6:05 p.m. It was rush hour. There was extra traffic going to a baseball game. There were 111 vehicles on the bridge, 13 fatalities, and 145 people injured. And you can see that the collapse of the river spans also caused collapses back into the approach spans. The NTSB investigation and recommendations, this information comes from the NTSB report. The cause of the collapse was inadequate load capacity of the gusset plates at U10, at the U10 node, due to design error. And the design review process was inadequate. The result was bridge design QA/QC process must be improved because the design error was not caught. In addition, we had distorted gusset plates at U10 and U10 prime that were not documented in the bridge inspection reports. As a result of this finding, the FHWA issued guidance and revised the bridge inspection training courses to emphasize gusset plates, inspection techniques, and non-destructive evaluation. Now, what's key about that finding is that gusset plates were not on the list of required inspection. Now they are, because there was no finding of an issue with anything except the gusset plates. So the bridge owners assessed the truss bridge, are to assess truss bridges to identify gusset plate locations that need non-destructive evaluation. Gusset plates became one of the core structural elements, so we now have 4. And bridge owners were required to calculate the load capacity of all gusset plates for all steel trusses, especially for bridge modifications. Second polling question. During inspection, the inspector should have A, reviewed all items specified on the inspection list, B, observed and noted that gusset plates were bowed, C, observed and noted that some gusset plates were a 1/2 inch and some were 1 inch, D, all of the above.
Okay, I'm going to launch the poll. You can click to answer. All right, 5 more seconds. Okay, our results, we have 5% said reviewed all items specified, 8% said observed and noted that the gusset plates were bowed, 1% said observed and noted that some gusset plates were 1/2 inch and some 1 inch, and overwhelmingly 85% said all of the above.
Okay, everybody in that 85% should pat yourselves on the back. Doing the minimum inspection, reviewing all the items specified, isn't all there is to the process. The inspector is there to bring the inspector's knowledge and experience And if you see something that should be a straight line and it's not a straight line, that should be observed and noted. And you can't possibly inspect the members in the superstructure, the substructure, and the deck without going past the gusset plates. You simply physically can't do that. So yes, you should look at the gusset plates, noticing they were bowed. And even if you take a photograph of their current condition and you go back and you say, gosh, I see from this photograph, they were bowed like that before, fine, but you do report it. Now, C is an interesting one. The design called for all gusset plates to be 1 inch. And of course, the inspector has the plans going in. The inspector is not expected to run around with a ruler and see if the gusset plates are all 1 inch thick. But trust me, if you have done any kind of work with structural steel members, you can quickly recognize something that is half of the inch depth requirement and something that is the full inch. You can see that quickly. You might not know that it's 7/16 or 9/16, but you can quickly see it's not 1 inch. And that should have been noted. So the answer here is all of the above. So February 11th, 2009, PennDOT issued Directive 2009. Now, I know you're not Pennsylvania, but I am. And so that's the example that I use. Almost all the DOTs did something roughly equivalent because the National Highway Administration required them to. So in publication 238, the Bridge Safety Inspection Manual, there were revisions to chapters 3 and 6. And they addressed the inspection and load rating of steel gusset plates. And those revisions were effective immediately. So as soon as this was put into play, all the inspectors had to go to a special one-off update training course. And then it was incorporated into subsequent presentations of the training course. All right. Now, what is non-destructive evaluation? Let me back up a second and say we sort of all know what destructive evaluation would be, like taking a core or slicing off a rivet to investigate the nature of the connection behind it. That's not really helpful because then you have a problem. You've created a problem. So we want to focus on tools for non-destructive evaluation. There are 3 in wide use. I suspect there are some newer ones out there, but have not achieved wide acceptance. So the 3 we're going to look at are ultrasonic, which measures plate thickness and detects cracks in flat, smooth members. You can use dye penetrant, which will detect cracks and welds. And there is a magnetic particle technique that detects subsurface flaws that you otherwise could not find until you were doing a postmortem. So there, for different purposes, you've got different tools, and they are, ultrasonic is, I think, the finest one, and I don't mean fine as in really, really good. I mean, it has the tightest, most thorough information as the outcome. The dye penetrant is a visual tool, and the magnetic particle one is the opposite of that. It's absolutely below the surface. So there are tools for doing non-destructive evaluation. Now, it's extremely labor intensive and expensive. So you want to do what you can to minimize the amount of non-destructive evaluation that you have to do. Okay, here's the outcome. The state of Minnesota paid $36.64 million to victims' families and survivors. The contractor paid $10.15 million in settlement of a lawsuit against it by victims' families and survivors, and paid $1 million to the state of Minnesota. That's to offset part of the 36.64. URS agreed to a $52.4 million settlement of a lawsuit against it by victims, families, and survivors, and paid $5 million to the state of Minnesota to offset against that 36.64. Since the bridge was designed, Jacobs Engineers had purchased Sverdrup, and they paid the state of Minnesota $8.9 million while admitting no wrongdoing. Now, I'm a lawyer, so that language doesn't shock me. But for non-attorneys, the idea of the design engineer, when there was clearly a design flaw, admitting no wrongdoing, gets your dander up. Well, here's how that works. In a settlement, you will always see language that says, we admit no liability, but we want to settle this, so we agree to pay X. That's standard settlement language, because if that language wasn't in there, then the settlement agreement could automatically create civil liability in other settings. So every settlement agreement I've ever dealt with since I became an attorney back in the 80s has had that sort of disclaimer language in it that says, I'm not admitting to liability, but I am paying a settlement. And so try not to take offense from seeing that language there. It's just a part of a settlement. What was different about the Jacobs Engineering one is they were not a part of the lawsuit, again, by the victims, families, and survivors. So their contribution was exclusively going back to the state of Minnesota. And the reason for that, by the way, is that, I'm about to get on a soapbox. I'll try not to get on the soapbox, but Jacobs bought Sverdrup's assets, did not buy Sverdrup's liability. But of course, once they buy Sverdrup's assets, there's nothing to back any liabilities. So there was only a shell left behind, which had no assets to pay any settlements, which is why Jacobs was not in the lawsuit. That's a conversation for another day. You are welcome to get viscerally upset about that, but that's a whole other issue, not ours. Okay, we're going to look now at the Code of Ethics and take a look at the canons that are in play here. Canon 1, engineers in the fulfillment of their professional duties shall hold paramount the safety, health, and welfare of the public. And Canon 3, engineers shall issue public statements only in an objective and truthful manner. Engineers shall be objective and truthful in professional reports, statements, or testimony. They shall include all relevant and pertinent information in such reports, statements, or testimony, which should bear the date indicating when it was current. Especially when you're evaluating current conditions, it's kind of important to know when current is. Now, remember, when we were talking about the bridge inspection requirements, qualifications, one member of the team has to be a PE. So the inspection report, the product of the inspection, must be sealed by a PE. So Canon 3 is automatically always in play with a bridge inspection report. And of course, Canon 1 is always in play because that is our primary duty above the client, above the desires of the client. Paramount is the public health, safety, and welfare. Okay, I wanted to give you the citation for getting to the Board of Ethical Review cases. It's on the NSPE website. There's a tab for ethics, and under the ethics tab, you can click on Board of Ethical Review cases. We're going to specifically look at 1910, 710, 17.3, and 005. And these are cases involving buildings or bridges and engineer reports. The engineer's report documented observed problems that would cause failure and endanger the public. And the engineer's responsibility is for accurate reporting and notification. And of course, when we fold those requirements into inspecting bridges, when inspecting bridges, the duty is to report observations accurately and take necessary actions. And that can include recommending a load capacity analysis and recommend repairs. Okay, the first case we're going to look at is 1910, public health and safety and observed structural defects and inspection by a county building official. Forensic engineer is hired by carrier, insurance carrier, to conduct a building investigation to determine the origin and cause of a fire. Now, I found a free use photograph of a building after a fire. Now, our building wasn't quite this bad, but it gives you an idea. During the investigation, forensic engineer, who is also a structural engineer, observes that the building is structurally unstable. Forensic engineer confirms that there were recent structural changes made to the building, after which a county building official issued an occupancy certificate. Forensic engineer determines that these changes may have caused the roof to sag and the walls to lean outward due to insufficient lateral restraint. Forensic engineer believes that although not imminent, collapse of the building is a danger. Forensic engineer immediately advises the carrier, recommends to the owners that they brace the building to prevent its collapse, and calls the county building official, who doesn't call back. Here is our next polling question. Did forensic engineer have any further ethical obligations? A, no. No further action was ethically required. B, yes, forensic engineer had an obligation to make sure that the building was stabilized. C, forensic engineer had an obligation to escalate the matter with the building official's supervisor. D, yes, the forensic engineer had an obligation to contact the fire marshal or any other agency having jurisdiction. Or E, yes to B, C, and D.
All right, I've launched our poll. I'll give you 5 more seconds. Okay, and our results. A, 8%. B, 2%. C, 17%. D, 8%. And E, 65%. So the majority said E.
Okay. This is why we do ethics training, because the correct answer is E. The forensic engineer, aware of a danger of collapse, had an obligation to do everything in the engineer's power to protect the public. That includes working with the owner to get the building stabilized, going over the head of the building official who didn't call back, and notifying anyone who has jurisdiction over the structure. So here's the BER's analysis. In this case, a professional engineer is presented with a situation involving a potential impact on the safety and welfare of the public. Forensic engineer brought concerns to the carrier and the owners and contacted the building official. Although forensic engineer did not believe the building was in danger of imminent collapse, forensic engineer had an obligation to continue to pursue a resolution of the matter by working with carrier and the owners. Forensic engineer, whoops, forensic's in there twice, sorry. Forensic engineer also had an obligation to contact the supervisor of the county official, the fire marshal, and any other agency having jurisdiction, advising them of the structural deficiencies. So that paramount duty to the public health, welfare, and safety drives the actions required of us, and especially when we're doing an inspection. The reason we are asked to do an inspection is to make sure that safety is protected in a variety of ways. Sometimes it's code compliance, sometimes there are other kinds of, contractual compliance. But the ultimate purpose of doing an inspection in the first place is to make sure that the structure is safe. All right, BER case 710, public health and safety, knowledge of a potentially dangerous condition. Engineer designs and builds a barn with horse stalls on his property. 4 years later, engineer sells the property, including the barn, to Jones. Later, Jones decided to extend the barn, and as part of the extension, removed portions of the columns and footings that support the roof. The changes were approved, the extension is built, and a certificate of occupancy is issued. Forensic engineer learns of the modifications and is concerned that the structure may be in danger of collapse due to severe snow loads. Forensic engineer verbally contacts the town supervisor, who agrees to look into the matter, but no action is taken. And again, I gave you a slightly exaggerated photograph just to give you an idea. Okay, polling question. What are forensic engineers' ethical obligations? A, nothing else, he's just guessing. B, nothing else, telling the town supervisor is enough. C, tell the property owner, Jones, of the concerns. D, give the township supervisor written notice. And E, follow up. If the town supervisor does not take action, notify appropriate state officials. And F, C, D, and E.
Okay, I'm going to launch our poll. We only have 5 options here. So if you choose F, you can type that into the chat box.
Didn't mean to make it overly complex.
Okay, 5 more seconds. Okay, we've got A, 2%, B, 2%, C, 6%, D, 22%, E, 69%, and we do have a fair number of Fs chosen in the chat box as well.
Okay, I hope that you're seeing a pattern here, that F is the correct answer. You need to do everything in your power as an engineer when you are encountering a safety issue. I've had some feedback in the past about A, that the engineer is just guessing that problems would arise from the removal. But in this particular case, and I didn't write this case, so I'm just telling you what the case says. In this particular case, our forensic engineer had designed the barn. The forensic engineer knew exactly what the load calculations were for each of the columns and footers that was removed. So he's more than just guessing. He has insider knowledge of the fact of the design specifications that are behind it. By the way, I want to address another question I get every once in a while, and that is, why am I reading what's on the slides? You can read too. Here's the deal. I serve as the board liaison to, or the staff liaison to the Board of Ethical Review. And those cases are incredibly carefully parsed. Every word is chosen with great care. And so paraphrasing those cases can be dangerous because each word is of significance. So when I'm giving you extracts from the case, I'm using the exact words, and that's what we need to be discussing and talking about. So in case you were wondering, that would be why. Okay, what the BER said. The forensic engineer should provide written notice to the town supervisor, the individual presumably with the most authority in their jurisdiction, including a reasonable period of time for action. In other words, let me know what you've done by Thursday, please. At the same time, the sequencing is a little bit off here. It would have been more appropriate to first provide written notice to the current owner of the concerns regarding the structural integrity of the barn. The owner is the person most equipped to protect the public. by bracing or supporting or putting in, jacks or whatever. So the actual sequencing should have been notify the owner and then notify the town supervisor. And 3, the forensic engineer should monitor the situation. If appropriate steps are not taken within a reasonable period of time, forensic engineers should bring the matter to the attention of county or state building officials as appropriate. So jack it up the chain if the local people aren't doing what needs to get done. Now, the word that should come to mind at this point is relentless. We have it in our power in these situations to protect the public health and safety. Licking a promise is not an acceptable technique for protecting public health, safety, and welfare. So I'm hopeful that you're seeing a pattern here. We have to be expansive and diligent and follow up. So again, the answer here was F. Okay, BER case 17-3, and I didn't mention this earlier, I forgot, I'm sorry. When you look at a BER case, the first 2 digits reflect the year the case was written. And the second one is just the case number within that year. It doesn't matter too much except for identification. But the first 2 digits gives you some idea of the age of the case. In this particular case, the year doesn't much matter. This is an ancient issue, an old issue, and so it comes up over and over and over again in different contexts, and the answer is always the same. Okay, forensic engineer is asked to look at a residential beam that has been burned. Forensic engineer observes that aside from slight fire damage, the beam looks too light to provide adequate structural support. Runs a series of calculations and determines that the beam was seriously underdesigned. Forensic engineer observes that since the house was a tract home, there are other identical designs in the subdivision. Guess what's coming? Forensic engineer writes the report, identifies the design defect, and expresses the larger concern regarding the possibility that an inadequate structural member was used in other houses in the subdivision. Forensic engineer submits the report to the insurance company. Forensic engineer, still concerned with an obligation to the public beyond just informing the insurance company, calls the State Board of Professional Engineers, apprises them of the situation, and asks what more could and should be done about the situation. Notice, forensic engineer did not call the NSPE ethics hotline. The board's response is that the forensic engineer fulfilled the professional obligations by notifying the insurance company in writing of the defect. Polling question. Was a written report to the insurance carrier enough? A, yes. B, yes. To avoid claims, the insurance carrier will be motivated to push for correction. C, no, should have notified the local officials. D, no, if there's a homeowners association, should have notified the HOA. And E, no, should have notified each affected homeowner. Or F, and I know this is going to be a chat one again, C, D, and E.
Okay, I've launched our poll. Again, if you choose F, go ahead and type that into the box. And Rebecca, we have about 6 minutes to go.
Right, I'm watching.
All right, I'll give you all 5 more seconds to get your votes in. Again, if you choose F, you can type that in the chat. Okay, our results: A, 7%, B, 7%, C, 37%, D, 2%, E, 47%, and lots of Fs in the chat box.
All right, so y'all are getting the hang of this. Okay, this is an unusual case. There's no question that he should have raised his concern with the local officials. Let me address B for a moment. B would work or might be a factor if the same insurance carrier was insuring all the homes. That's highly unlikely. So the particular insurance carrier's motivation to push for correction is most likely illusory. So that's why that one doesn't play. The homeowners association is an easy one. You can notify the homeowners association, recommend that the individual homeowners with that type of house get an inspection and an evaluation. Do not put yourself forward as the person to do that. That is like ambulance chasing. On the other hand, you are the person who brought it forward, so you're likely to get those calls. The only one that's iffy here is E. Notifying each affected homeowner is based totally on the assumption that the same beam size was used throughout. That is a guess. So you could make an argument that it would be presumptuous and disruptive to notify each affected homeowner, but that would be the most effective way to get the word out. So here's what the BER said. A state engineering licensure board, while an important guidepost in determining appropriate conduct, establishes the legal minimum standards of practice under which an individual may be subject to disciplinary action for failing to fulfill the appropriate requirements. However, the NSPE Code of Ethics establishes a higher threshold of ethical conduct. Contrary to the advice of the State Board of Professional Engineers, Engineer A did not fulfill his ethical obligations under the NSPE Code of Ethics by only providing the report to the insurance company. Although a threat isn't imminent, this matter had the potential to affect several other homeowners in the subdivision. Engineer A had a responsibility to take additional steps beyond merely submitting a written report to the insurance company, including contacting local building officials, individual homeowners, and the homeowners or community civic association to advise them of the finding. So the BER's finding was all of C, D, and E. All right, we have one more case, but before I go to the final case, because you have access to the PowerPoint, I want to see if there are any questions. Do we have any questions out there? I want to make sure they get answered if we do.
Yes, going back to the bridge. The inspector has authority to close the bridge or just make recommendation to close the bridge?
The inspector does have closing authority.
Okay.
So for example, if the inspector in Memphis had noted the crack in the bridge, the inspector in Memphis would have had authority to shut it down immediately.
Okay, and was URS the bridge inspector?
I would have to go back to the first slide. I believe they were not. My recollection off the top of my head is that they were one of the intermediate designers of one of the improvements. But I could be wrong about that.
We did have one more question. Can you retype your question into the question box, and I will make sure that that gets answered.
Okay.
And Rebecca, you can go ahead.
Okay. I'll talk really, really fast. BER case 005, public health and safety, observed structural defects. Engineer works for the local government. The bridge inspector notifies Engineer A that a 1950s concrete deck bridge built on wood piles needs to be closed due to rotten pilings, 7 of which need immediate replacement. The photograph to the right shows you what happens when a deck piling rots out. As you can see, it does not reach the ground. Engineer A had barricades and signs erected within the hour on a Friday afternoon. Residents in the area were required to take a 10-mile detour on the following Monday. The barricades were in the river and the bridge closed sign was in the trees. More permanent barricades and signs were installed. The press published photos of the piles dangling over the river because they no longer reached the ground. Within 3 weeks, Engineer A had obtained authorization for the bridge to be replaced. A petition asking that the bridge be reopened to limited traffic was presented to the county commission. Engineer A explained the extent of the damages and the efforts underway to replace the bridge, and the county commission decided not to reopen. A non-engineer public works director decided to have a retired bridge inspector, who was not an engineer, examine the bridge. The non-engineer retired bridge inspector recommended that 2 crutch piles be installed under the bridge and open the bridge with a 5-ton limit. The non-engineer public works director agreed. No follow-up inspection was undertaken. Engineer A observes that traffic is flowing and the movement of the bridge is frightening. Log trucks and tankers, both of which are well over the 5-ton limit, cross it on a regular basis. School buses, wisely, are going around. We're going to skip this polling question. What are the ethical obligations? Get the 5-ton limit enforced, get support, evaluate the 2 crutch piles, and report the non-PE bridge inspector. What the BER said, Engineer A should take immediate steps to ensure enforcement of the 5-ton limit. And if that's ineffective, contact state and federal officials, the state licensing board, the director of public works, the county commissioner, state officials, and such other authorities as appropriate. Anybody he can put his hands on. Engineer A should work with the consulting engineering firm to determine if the 2 crutch piles are sufficient. And in addition, Engineer A should determine whether a basis exists for reporting the activities of the retired bridge inspector as unlicensed practice. The answer here is 2, 3, and 4, maybe 5. Okay, there are my references, and we've gone through questions, and so I'll leave that up for a moment. And I am very grateful for your attention. I hope you took away something useful.
Thank you so much. We do have one last question I want to get to about the barn. We're focused on ethics today. However, does it matter that the barn is a private structure from a legal perspective?
It does not. Public is public, and the public means anybody. So it's the people mucking out the stalls are the public, the people who ride the horses stabled in the barn are the public, the owner is the public. So public is very broadly viewed when determining where the obligations trigger. It is not a function of whether the facility is owned by the public.
Okay. Great. Well, thank you so much for your time this morning. We really appreciate it. Everyone on the line, thank you for being with us. We're going to take a 15-minute break. We'll be back at 11 o'clock with our session 3. Rebecca, have a great day. Thank you so much.
Thanks. Take care.
Bye-bye.
Bye.